Hello guys, and welcome to another episode of my lecture. This is Olayeni Dear Kolola Daniels, and welcome to another episode of D.C.O Talks Law. On today's episode of D.C.O Talks Law, we will be talking about the doctrine of notice under the law of equity. In my last series of lectures, I've discussed the 12 maxims of equity from the 1st to the 12th. And I've also discussed under the doctrine of notice, the doctrine of actual notice. And today, we will be discussing constructive notice. In subsequent lecture, which is the immediate next lecture after this, I will be discussing imputed notice. Do note, like I've explained in the last lecture, when you are about to buy land or sell land and stuff like that, as the buyer, it is very important that you understand the doctrine of notice. The last class where I discussed actual notice, I told you how anything that you can see on the land would be regarded as actual notice on you as to the existence of that thing. And in this case, we are talking about constructive notice. In the next lecture, we will discuss imputed notice. But before I go straight into our lecture for today, if this is your first time of coming to my channel, then I want to say a very big welcome. Thank you so much for coming to my channel. Please make sure that you click the subscribe button as well as the notification bell, so that anytime I release a video which is going to be of interest to you, you, my friend, will be one of the first set of people to watch that particular video. Now, going straight to what we are to discuss today, which is the doctrine of constructive notice. The principle of equity is that where the purchaser would have discovered the existence of the equitable interest if he had used ordinary due diligence and care investigating the property and its title, he is deemed to have notice of that interest even though he wasn't aware of it, as stated in the case of Barclays Bank D.C.O versus OLOFINTUYI. Now, what exactly is this telling us? This is telling us that although this person in question, the buyer in question of this land, does not have notice of this particular equitable interest, however, he doesn't have actual notice, not any other notice. He doesn't have actual notice, which means that when he went to the land or when he went to do something, he did not actually come in contact with the equitable interest in question. However, if he has taken due diligence, he has done due diligence of any kind, and he has taken care, he would have found it. For example, you want to buy land and the person is presenting to you a C of O. It is only but due diligence for you to go to the registry, because that C of O must have been registered, so that he will not go and present a fake C of O to you. Abi, we are in Nigeria now. If somebody present a document for you, somebody you don't know who is allegedly the seller of the land present a document for you, are you to take it hook, line and sinker to be true? If you still do that in Nigeria, then I don't think you have been living in Nigeria for a very long time. So when you see a document of such nature, you go to the registry and cross check. Is it the same thing? Is it the same person? Is it the same land? Those kind of things. But when you don't carry out your due diligence in going to cross check, in making sure that this person is not an imposter or a fraudster, which ordinarily, if you are done, you would have found out certain things. Those certain things that you would have found out, although you don't know it, will be deemed that you know it. Sure, you get? Do you understand what I'm saying? Although you did not know all those things, but if you had done due diligence, you would have known it. Therefore, the court will impute it on you that you know it. Do you understand? And that was stated in the case of Barclays Bank D.C.O versus OLOFINTUYI. Now, in the case of Birch and ELLAMES, a purchaser of land was held to have constructive notice of an equitable mortgage created by deposit of title deeds because he knew that the deeds were deposited with some people and he failed to inquire into the reason. Now, the case of Birch and ELLAMES is a practical example of what I'm talking about here. Now, you want to go and buy land from somebody. You are a purchaser, a buyer. You want to buy land from somebody, and the person is telling, my guy, now, how far are you there? And you're like, chairman, I do, how far now, how far things? And you guys were exchanging pleasantries and all that, and you're like, I want to buy this land. You say, now 50 million. Okay, no problem. You carried the 50 million, you gave it to him, and then you now say, okay, where is the title deeds, the document to the land? And he say, you see, I gave it to my uncles, brothers, aunties, nephews, son. Someone gave you such a long story like that you say, hey, is that what you did? Okay, no problem. Now just let me go and collect it, and I move. And then he left. But that person has used the title deed to deposit in bank for a loan. Now, if this person in question, that is the buyer, had done reasonable diligence, you gave it to your uncle's, auntie, whatever, so no problem. Can I go and see the person and ask if it is true? Or do you understand what I'm saying? Due diligence to be sure before you hand over the money. You have not seen the title deeds, you already handed over the money. How? Why would you do that? So because you were lackadaisical, and you were careless, and you were negligent, you did not take due diligence and all that, the court will deem it that you knew. The owner of the land in question had already deposited the title deeds to a bank and collected mortgage, created an equitable mortgage, collected money, and you are hearing his bobo, his lie, that he has given it to one person. Why did you give it to the person? Can I talk to the person to ascertain that it's there? Can I talk to the person to see it? If I can see it and I know that this thing is where you say it is, then there's no problem. But you hadn't seen it and then you gave over the money. That is where the court will have problem, and then the court will impute the notice on you. Let us also go to the case of Peto and Hammond. A purchaser was held to have constructive notice where he neglects to call for the deed or is satisfied with an unreasonable excuse for their non-production. The same thing I just said now. Same thing in the case of Birch and ELLAMES, where he said that I have given it to someone, but then he gave it to the bank to collect mortgage. He knew that he had given it to someone, but he failed to make inquiry. Peto and Hammond is now telling us that where he neglects to call, this one you did not even call for the deed. You just gave the money and then you walked away. Fantastic. You have money, you just drop the 50 million and then you say, I have other things to do, and then you walk away. You see that you're walking away. As you are coming back with constructive notice on your head, because where you fail or you neglect to call for the deed, or you are satisfied by an unreasonable excuse for their non-production, or when you ask the owner, the seller, so where is the deed now? You see, I kept it in one house like that and the house burns. Don't worry, we are working on these people, 419 people, when they give you excuse, knock you with bobo from left and right, you will lose guard. If you lose guard in such a manner, the court will not come to your aid. Do you understand that? The court will not come to your aid. So there are two instances, as we can see in the case of Birch versus ELLAMES and the case of Peto versus Hammond. The first instance is where you neglect to call, and the second instance is where you are satisfied by an unreasonable excuse. Do you understand? And then we go further with our note. Constructive notice, therefore, makes it imperative for a purchaser not only to inspect the land, but also to investigate the title of the vendor. The consequence of a defaulting purchaser can be very serious, because occupation of land by tenant is a notice of his interest and the purchaser takes subject to the tenant's land. So this is it. According to what we have seen, not only are you supposed to go to the land to inspect what you find on the land, you are also supposed to go and inspect the title. And I have told you, inspection of the title takes place in the registry and any other relevant places, maybe stamping and all that, and signature. Make sure you go to every relevant place that you're supposed to go to cross-check that everything that has been stated in the title deed is correct. In your title deed, you are going to have a recital. A recital is where you have all the purchasers of this land or all encumbrances on this land before you got it. It is going to be sensible for you for where they have said, oh, I took mortgage in 2015. Let's say this is currently 2020. In the recital of the land, you saw that there is an equitable mortgage in 2012. Somebody took an equitable mortgage in 2012 and he discharged the equitable mortgage in 2015. Go to the bank and go and cross-check. Is this thing discharged? You have to be sure, because if you go and buy it and you say, oh, I saw discharge there, and you go and, you can enter trouble at the end of the day. So in order to avoid trouble, before you get that money over to the seller, make sure that you investigate the title, not just the present, the past, and any other encumbrances that you have. Let us take the case of Kabba versus Young, for example. The plaintiff, P, claimed possession and meant profits. In case you don't know what meant profit is, when somebody is on your land, for example, you are the landlord and then you have a tenant on the land, and every year he's supposed to pay you 500,000 naira as rent for the land. Now in 2020 he paid you 500,000 naira, but in January 2021, when his tenure has elapsed, his whole time to stay has elapsed, oh yeah, Ogana, my money. He didn't give you. You gave him notice, 3 months notice. Oh yeah, leave my house, or 6 months notice. 6 months later, he did not leave. You went to court because of the way court is and all that. 1 year later, he has not left. He did not give you rent. He did not give you anything. Now, when the court finally decides the case, you see all those times that he didn't pay you. What he will pay you would not be called rent. It will be called meant profit. Do you understand that? Where the time has elapsed for a tenant to pay and he doesn't pay for a long period, and then he finally is ejected from the land. Let's say the landlord won the case. Those times that he stayed on the land without paying, what he will pay for those times would be what? Meant profits, and not what? Rent. Do you understand? So that, like I was saying, the plaintiff claimed possession and meant profit in respect of certain premises, which was resisted by the second defendant on the ground that he was in possession through his tenant, the first defendant. That is why. So we have three people here: P, plaintiff; X, second defendant; and Y. Now, X is the person in charge of the property. Are you listening? But X kept his tenant who is currently in possession. Why? Do you understand? Now P wants to chase both X and Y out of the property because P is the purchaser of this property. X is the one in charge and X kept Y there. Then when P came and said, oh yeah, I have bought this property, X is saying, are you blind? You bought property. Didn't you see that Y is in the property? That means that should serve as notice to you that there's somebody here. You cannot chase me out now. Then he is now claiming possession of the property and the immense profit. Now, the judge found on fact that the plaintiff, that's P, bought the land from the vendor, but prior to this, the second defendant, X, who I told you is in charge, had paid to the vendor part of the sum of the money agreed upon for the premises. Now, look at it. Now, in relation to this property, we have 4 people. Are you listening to me? The first person is P, the new purchaser. Put him one side. The second person is X, the person in charge of the house. He's the one in charge, but he's not the owner. The owner there is the vendor. Now, the vendor told X, who is in charge, to give him part payment, which X had already given him. And then that same vendor, being a thief, because that is what I can see, then still collected money from plaintiff. That is P. Are you listening to me? X paid money to the vendor to acquire the property. Vendor collected money from P for that same property. Let's go back again. The judge found on fact that the plaintiff, P, bought the land from the vendor, no problem. But before that, that's prior to that, the second defendant, X, had paid the vendor part of the sum of money agreed upon for that premises. Can you see where problem is now? Now, before the plaintiff purchase, the vendor had told the first defendant, why? Baba tenants had told Y, who is X's tenant, to pay rent to who? To X, and the plaintiff was aware of the fact affecting his title. Are you seeing problem now? Plaintiff, you can see clearly, as it is obvious, that there are people in the building. You have X, you have Y. You still gave your money to the vendor without telling him, Oga, clear these people out before I give you my money. You know, what did the court say? The court held that the notice of the land being in occupation by a person other than the vendor who you paid money to is notice to that purchaser P that the person in possession has some interest in the land, and a purchaser having notice of this fact is bound by all equities which the defendant could enforce against the purchaser. The plaintiff claim for possession was denied. Yes, so the court agreed with you that you paid money to the vendor as the owner of the property. But did you have notice that someone else was occupying the property other than the vendor? Yes, you did. Even if you want to say that you did not go to visit the property, as you should have. Because if you had gone there, you would have seen that there is somebody there other than the vendor. Do you understand that? And since that person has paid rent, you would have to wait until his rent expires before you then go into possession of the land. And that was what was held in the case of Kabba versus Young. And then lastly, we talk about two other cases. The case of Omosanya versus Anifowoshe and Daniels and Davidson. What did the court hold in Omosanya and Anifowoshe? The Supreme Court held that where a party has a building on a parcel of land and has put in the building a tenant, this should constitute notice of his equitable interest in the property, which must be protected. That is the tenant. The tenant has an equitable interest in that property, and that equitable interest must be protected against any buyer of that property. We then go to the case of Daniels versus Davidson. It was held that as part of examining of the title deeds of a property, the purchaser should also inspect the land itself, as he will be deemed to have constructive notice of the interest of any person in occupation of that land. I think at this point it is very clear that when you are talking about constructive notice, there are three things you should look at. Number one, look at the title deed. When you look at the title deed, go and cross-check it in the registry and every other thing. Number two, when you are about to buy a house, when somebody gives you an excuse, go and look, what is your excuse? You've given it to somebody. Oh yeah, carry me to that person, let me see the person. Oh yeah, person, oh yeah, where is my title deed? If the person cannot show you, don't give him the money. Any unreasonable excuse, go and find out why that excuse is so. And also, do not neglect to ask for the title deed. That is where you are going to have a problem. So the first one is where you have the title deed, go and investigate. The second one is when you have been given an unreasonable excuse, investigate on that unreasonable excuse and do not neglect until you see that title deed. And the third one, when you see the title deed and everything checks out, still go to the land and inspect. Ask questions from people around. Is there any other person living here? Are people living in this compound? Who lived here before this person? Can you please attest that this person is the owner of the land? All those things are what they call due diligence and care when you are buying a property. And with that, thank you so much for watching this video. As we have come to the end of the lecture, make sure that you subscribe, like and share these lecture videos with your friend. In my next class, we will be talking about imputed notice. And with that, I will see you in my next class. Do not forget to follow me on LinkedIn at D.C.O. and do not forget to like, share and subscribe. Also click the notification bell. I will see you in my next class.